Hello, everybody. Nice to see you. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Today, I have an interesting topic I want to share with you. After a jury verdict in a medical malpractice case, will the jury want to see you? Will they want to talk to you to ask you questions about your particular case and about certain testimony that you gave in your case? You want to learn the answer? Come join me for a few moments so that I share with you the answer to that question. All right. Hello, everybody. Today I'm talking about something that's very interesting involving someone who brought a lawsuit who thinks that their doctor was careless and that his carelessness was a cause of their injury and that their injuries are significant and permanent. The doctor whom you sued, on the other hand, turns around and says, you know what? I did nothing wrong. Why are you suing me? Right? That's the first thing he says. Why are you suing me? I did nothing wrong. Then he says, you know what? If I did something wrong, then he says, so did you, Mr. Patient. And if he says, hey, why are you suing me? I did nothing wrong. And whatever I did didn't cause or contribute to your injuries. That's his second defense. Whatever he did didn't cause or contribute to your injuries. Then he turns around and says, you know what? Even if I did something wrong, and whatever I did, hey, Rob, nice to see you. And whatever I did caused or contributed to your injuries really are not as bad as you claim them to be. Those are the typical defenses we see in these medical malpractice cases here in New York. So, let's get back to the question I asked earlier. Can or will a jury at the end of your case, after 2 or 3 years of hard-fought litigation, will they, after your case goes all the way to trial, and now you spend a week, 2 weeks, 3 weeks or more on trial, and now a jury comes back and reaches a verdict, whether they give you a verdict in your favor or on behalf of the doctor's favor, regardless of their verdict, will they want to talk to you, the injured patient? And the reality is, in all likelihood, the answer will be no, they won't want to talk to you. Now, don't get offended. Don't be afraid of that. Why? Because here's the reality. The reality is that jurors who sit on these types of cases, they are coming from all walks of life. They have not been chosen. They have not voluntarily given their time to come into court to sit in judgment of your case, right? They haven't done that. Nobody raised their hand and says, hey, could you pick me for jury duty, right? Nobody does that. Nobody wants to say, hey, take me away from my work, take me away from my family. Let me go ahead and spend days or weeks in court listening to your particular case. Nobody does that voluntarily. Why? What happens? You know what happens, right? What happens is that you get a summons in the mail that says, hey, you are to report for jury duty on this date and this time. Or a more lenient way to describe it is you get that summons that says, hey, we need you for jury duty. You don't have to come in on this date, but you have to call in each and every night to see whether you're needed to come in for the next day. That's what typically happens. Hang on 1 second. Okay. So these medical malpractice cases here in New York, they typically take 2 to 3 years to go from the start all the way till you get to trial. And there's a lot of different reasons for that, but you should know that the litigation phase, the pretrial litigation phase, takes about 2 years or so, right? Then once your case is ready for trial, now it's going to sit on the trial calendar. And on the trial calendar, depending upon which county you are in, could take 6 months to get to trial, could take 9 months, could take 12 months or more. So what happens then is that now your case finally comes up for trial. Your attorney has prepared you for trial. He's prepared you for cross-examination. He's got all of his exhibits lined up. He's got all of his experts ready to go and prepared to go. The defense, likewise, has their experts ready to go. Okay, so what happens then? What happens then is that now the attorneys have to go in and pick a jury. They go ahead and pick a jury. It could take a day, maybe 2 days. And now you are assigned to the first available trial judge. And when the trial judge is available, now he tells the attorneys to come in and he says, counselors, what's this case about? And why would he do that? Because he wants to know from the attorneys what this case is really about. He's had no contact whatsoever with the litigants. He doesn't know the attorneys who are handling this case, most likely. And even if he does, he hasn't dealt with them on this particular case. So he says, what's this case about? Now, you should know that's not an opportunity for the attorneys to go ahead and give a long-winded half-an-hour explanation. He really, excuse me, Oh, wow. He really just wants a 1 or 2 minute summary of what this case is about. Judge, this case involves a 42-year-old woman involving a failure to diagnose breast cancer case leading to the fact that she now has stage 3B breast cancer. That's what he wants to know. And from the defense, he wants to know, hey, number one, do you agree? Or are you defending this? Do you say nothing was done wrong? Or do you have money to put up on this case? Are you willing to negotiate? That's what the judge wants to know. So now let's assume that the defense is refusing to negotiate. Let's assume that the defense wants nothing to do with any type of settlement discussions. And they say, Judge, we have to try this case. We need to get a verdict. So, the judge says, fine. We will start trial tomorrow morning, and now we'll make opening arguments at that time. All right, great. So now, your attorney goes on and puts on all of... Hi, Billy. We got my cat in the back here. Where are you going, Billy? So... Yeah, thank you, Billy. It's the one and only time our cat has meowed, wants to go out. All right, so let's get back. Really? Hello, kitty cat. All right. Now it's the only time I can go ahead and actually address the cat while I'm on video. How do you like that? Yeah. Mother, could you let him out, please? Thank you. Okay, so now you're on trial. You're on trial for days and weeks, and your attorney puts on all your testimony. He puts on all your evidence. The defense goes ahead and cross-examines each one of your witnesses that you put on to testify. Great. Now it's time for the defense to put up their defense. They put on their medical experts. They put on their witnesses, and your lawyer has an opportunity to go ahead and question and cross-examine their witnesses. So now what happens then? Well, at the very end of the case, each attorney has an opportunity to make closing arguments, right? And now, after the attorneys have finished making closing arguments, the judge actually gets the last word in. The judge is going to instruct the jury on the law. Ladies and gentlemen, I'm going to explain to you what the law is in New York as it applies in this particular case. And then he'll go ahead for at least an hour, giving them explicit details about the definitions of certain things, what is medical malpractice, and what they have to evaluate in order to determine whether the injured patient is slightly more likely right than wrong that what she's claiming is true. And interestingly, did you know that there's a very interesting legal instruction talking about credibility of witnesses? You want to know what that is? There's a legal phrase for it. It's actually a Latin phrase. It's called falsus in uno. And hey, Brian, nice to see you. Pretty cool. Thank you so much for the thumbs up. So falsus in uno, you know what that is? That's an opportunity for the judge to tell the jury, listen, witnesses' credibility are everything. And if you find that a witness has testified falsely about one little thing, even a little white lie, you have the right, you have the ability, you have the opportunity to disregard everything that they have testified about. How powerful is that? Which really means that your believability, your credibility is everything in this case. So that if you tell a little white lie, and now it comes out and the defense lawyer brings it out that you did in fact lie, now he's going to harp on it over and over and over again. Why? Because he's going to argue to the jury during closing arguments, hey, ladies and gentlemen, you're going to hear the judge tell you that if you find that this witness has testified falsely about one little thing, you have the right to disregard all of his testimony. And that could destroy your case. So now, you've been in court each and every day. You're sitting and listening, and it's like an emotional roller coaster because sometimes you feel great, you're on an emotional high, other times you're on an emotional low. And this will go on each and every day depending upon whether your witness is doing great, or whether your attorney is doing great, or whether you're getting destroyed and you feel like the world is ending and your case is ending. And that's what happens during the course of these trials. It really is an emotional roller coaster. And the bottom line is, you don't know what's going to happen when the case goes back to the jury and the jury will go back and deliberate. You don't know what the outcome is going to be. The defense doesn't know what the outcome is going to be. So now you've got two sides that have no clue what the outcome is going to be. So you're relying on 6 members of the community to go ahead and tell you, yes, we believe you, or no, we don't. That's the bottom line. All right. During the course of your trial, I guarantee you that you're going to have questions. You're going to have questions about strategy that your attorney is using. You're going to wonder why he's asking certain questions. You're going to wonder why the judge is ruling certain ways. You're going to wonder why certain objections are made and why the judge is ruling on behalf of one attorney or another. And now, based upon those questions, you're thinking, what's the jury thinking as they hear various testimony? You would love to go ahead and approach the jury and say, hey, juror number 1, what do you think about this witness? Juror number 2, what do you think? Hey, juror number 6, tell me what you thought about this witness and what he had to say. What do you think of my attorney's cross-examination? I mean, there's so many questions that you're going to have. And now, you are hoping that at the very end of the case, first of all, you hope that you're successful, right? And knowing you, in all likelihood, you feel that you will be successful. Because how could the jury decide otherwise? You have a very strong case. Your experts have all said you have a very strong case. But let me get back to reality. The reality is, even with a strong case, even with excellent experts supporting your case, you could still lose your case because there are no guarantees. The jury may not like you. They may not believe you. They may not believe your witnesses. It could be a variety of factors. But now you would love nothing more than to actually watch the jury deliberate and decide the questions that they have to answer, because that's really what they have to do. The jury is tasked with answering a series of questions, and the answers to those questions make up their actual verdict. Did you know that? They don't just come out and say, okay, we give you a verdict in your favor, and that's the end of it. And here's how much money you are to receive. No, that's not how it works. That's not how any of it works. So how does it work? All right, I'm glad you asked because I'm here to explain it to you. That's what I do. That's what I do each and every day. I'm here explaining how these types of cases work, and I think it's helpful and educational for you to learn how these types of cases work so that if you have a question or if you want to learn more about your possible matter, now you have the opportunity to learn this stuff. All right, so where were we? Oh, okay. So you have questions, right? The jury now goes back to deliberate after they've heard the judge instruct them on the law. And now the series of questions they have to answer starts typically with, was the defendant negligent? Now, what does that mean? It means, was the doctor whom you sued, was he careless? Did he violate the basic standards of medical care? Right? That's the very first question they have to answer. If they answer no, he was not careless, guess what? Your case is over. Your case is finished. And you get nothing. Nothing. Zero. Nothing. Your case is done. If, on the other hand, the jury said, yes, you know what? The doctor was careless. Terrific. Now they go on to question number 2. Here we go. Question number 2. And what's that question? Was the doctor's carelessness a cause of your injury? Interesting. Now, what is that about? In law, we call that causation. There has to be a proximate cause. There has to be a link, a bridge between the doctor's carelessness and your injury. All right? If there is no link, guess what? Your case is over. Your case is finished. And you walk away with absolutely nothing, regardless of how long it took you to get to trial, regardless of how much effort and energy and time your attorney put in, and how much money he spent to prosecute your case. It doesn't matter. If the jury comes back and decides that, hey, you know what? The doctor may have done something wrong, but whatever he did didn't cause or contribute to your injury, guess what? You lose and you're out of luck. All right, so let's assume now that the jury has decided, yes, your doctor was careless. And yes, his carelessness was a cause of your injury. It only has to be a cause. It doesn't have to be the cause. Very important distinction. So let's say they find, yes, there is a connection between the wrongdoing and your injury. What do they have to do next? Well, the next thing they have to do is now decide how much money to give you. That's a very interesting component of your case. Now they're going to focus on damages. And there are many elements of damages. There's pain and suffering. There's economic losses, things that we can actually calculate, such as your lost earnings. Right? So there's a difference between economic losses and non-economic losses. But that's a topic for another day. The bottom line is that the jury will then begin to evaluate how much money to give you as a form of compensation for all of the harms and all of the losses and all of the injuries that you suffered because of his carelessness. Okay, so now they've answered each one of those questions. And by the way, you should know something else. And this is something that not many people talk about. So come closer for a little bit, right? There are 6 members of the jury deciding your case. and there are some extra jurors in case one of those 6 are no longer able to continue. But those 6 jurors, assuming they are all there throughout the course of the entire trial, and now they've deliberated, or they are deliberating, they're going to decide whether you are entitled to a verdict in your favor. They're going to decide how much money you are to receive. And that's a very important function of serving as a juror, serving jury duty. So now, they've made their decision. They've come up, oh, by the way, so this is what I was talking about. So in New York, you don't need all 6 jurors to agree on each one of those questions that they have to answer. Instead, you only need 5 out of 6 jurors to answer. That's a really important point. So it doesn't have to be unanimous on each and every question. It only has to be 5 jurors. And on each and every question, it doesn't have to be the same 5 jurors. It could be different 5 jurors. All right? So now you know some inside secrets about how these types of trials work here in New York. So let's get back to the question that I raised at the beginning of this interesting video. At least I hope you think it's interesting. The question is, after the jury has reached their verdict, and now they announce their verdict at trial, they announce it to the court in open court, the judge is going to thank the jury for their service, right? That's exactly what he's going to do. He's going to thank the jury for their service. Ladies and gentlemen, thank you so much for your service. We could not have accomplished this without you. And you are either going to be extremely happy with the verdict, or you're going to be extremely depressed if the outcome is not in your favor. That's a fact. So, what happens next? Now, the judge is going to tell the jury, listen, ladies and gentlemen, you are now free to go. The attorneys may want to talk to you. The litigants may want to talk to you. You are under no obligation to stick around and talk to them. You are welcome to go. Have a wonderful day. Your service is over. And now, there are many jurors who, at the first moment they can, you know what they're going to do? They're going to bolt right out of there. They don't want anything else to do with the attorneys. They don't want anything else to do with the judge. They don't want anything to do with the court. They want to get home to their families. They want to get home to their life, to their work, and to everything else that they do. Why? Because they've been sitting there for days and weeks, now trying to figure out how am I going to get things done at home, at work, and everything else that they do each and every day. So, to answer the question that I raised at the beginning of this video, can you, as the injured victim here, can you try and talk to the jurors? The answer is you could try and talk to the jurors. Most jurors will not want to talk to you. Most jurors, even if they gave you a favorable verdict, will not want to talk to you. At best, they may be willing to talk to your attorney for a brief period of time. And when an attorney does get to talk to the jurors, it can be very eye-opening. It can be eye-opening because we, the attorneys, the litigants, the judge, the court personnel, we were not in the jury room at the time that they were reaching their verdict. We don't know what they talked about. We don't know how it was that they came to deliberate and how they came to a consensus to reach each and every answer to that question, to the questions that they were asked to answer. We don't know. There's no video in there. There's no audio there. So we don't know what it is that they talked about. And we would love nothing more in reality to learn what it was that they said, what they did, what they thought about the different witnesses, what they thought about different cross-examination techniques, and what they thought about the opening arguments, closing arguments, what they thought about the judge. We would love that. I would love that. It would be amazing. But the fact is, those are confidential discussions. Those are privileged. There is no way that we can go ahead and be a fly on the wall. There's no audio. There's no video recording of it. So the only thing, the best thing we can hope for, if we want to talk to the jurors afterwards, is to try and catch a few of them before they head out the door and head back to their lives. So to answer the question, can you talk to the jurors? The answer is, you can certainly try. Will you be successful? Don't know. The answer is maybe yes and maybe no. Well, that's it for today's video. I hope you enjoyed it. I hope you found it useful. I hope you found it educational. And as always, if you have questions about your matter that happened here in New York and have not yet started a lawsuit but are contemplating, you're thinking about bringing a lawsuit but haven't done so yet and still have questions, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @ Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day, everybody. Bye-bye.